The homeowner passed away about 2.5 years prior to this. He left the house one morning to go for a jog, as he typically did, and he had a heart attack and died instantly. It took the court more than a year just to locate an actual beneficiary. Now, someone asked a great question in the first video, the intro video that I did about this, and they asked if a trust is different than a will, and it is. A will is basically a list of instructions. It does not avoid probate. The court still has to validate it, confirm who the heirs are, appoint someone in charge, and approve anything involving the property. It's useful for personal items like rings, furniture, clothing, sentimental belongings. It outlines who you want those things to go to, so there's no confusion. It does not give anyone legal authority over the property, so it doesn't give anyone the right to sell the property or even sell vehicles or land. A trust is set up by the homeowner while they're alive. They choose a trustee, someone in charge, and the beneficiaries. When the home is placed into the trust, it becomes the legal owner. When that person passes away, there's no court involvement, no delays, no probate. The trustee can actually act immediately. They just need a copy of the original trust. Okay, so here's where this specific case becomes complicated. My guess, based on everything that I heard and saw, is that the homeowner may have created the trust, but the deed was never transferred into it. And if the deed isn't recorded into the trust, then legally, the trust does not own the home. You look at the tax records, it may say Christina Smith owns the home. But if the deed has been recorded into the trust, it would say Smith Trust 2025. So when this particular owner passed away, the tax records obviously still showed the home in his name. There were no immediate beneficiaries on site to look through his belongings, no one to find documents, no one who knew whether the trust even existed. So as far as anyone knew, there wasn't one. If there's no trust and no heirs and no beneficiaries, how does the house get into probate? So in this case, there was a loan against the property. The bank cannot just foreclose. They have no legal recognized person to foreclose against. The home sits until the courts step in. When the courts take over, they follow a strict legal order to determine who the heirs are. It's called intestate succession, and it always goes in this order: spouse, children, parents, siblings, nieces and nephews, grandparents, aunts and uncles, first cousins, and extended relatives. And if none of those exist, the estate eventually goes to the state. If you have any questions about this, you can private message me. Otherwise, on to part 3.